Welcome to Online Divorce Lawyer. I'm Lynn Lucas, and this video is to show you how to find your way through the 4 steps of a divorce property settlement. Once you've decided to separate and to divide your property, it's important that you obtain legal advice as to your options and the basic process of a divorce property settlement. There are 4 steps, and to make it easier for you to understand the process, we set out the 4 steps that you need to take, explain how to prepare for an appointment with your lawyer, and be familiar with the documents that you'll need to produce and exchange with your former partner. A summary of the 4 steps is that firstly you ascertain the assets and liabilities, then consider the contributions of both parties financially and non-financially, consider whether there should be an adjustment for future needs factors, and finally look at the superannuation, whether there's going to be a split or no split of those funds. So the first step is to ascertain assets and liabilities. Firstly, you've got to work out what makes up the pool of assets and the equity in those assets that are to be divided between you. Best to make a list. So make a list of your assets, add those up, a list of the liabilities, add those up, then deduct your liabilities from the assets, and the result is the equity you have in the property that you both own. To be able to move forward with your settlement negotiations, you must agree on asset values, because if there's any dispute, you must both agree on and appoint a registered valuer for real estate, contents, business, etc. The Family Law Act provides that both parties must make full and frank disclosure of all of their assets and liabilities at the time of the settlement, and this is done by producing documentary evidence. This will have to be produced to your lawyer and also exchanged with your partner. So the documentary evidence is really your savings and cheque account statements, superannuation member statements, anything to do with your employment such as pay slips, tax returns, company financial statements, and anything with your liabilities such as your mortgage statements, loan statements, credit card statements, etc. We must look at both assets and liabilities. It's going to save a lot of time if you can gather this evidence at an early stage and ensure that copies are provided to your former partner and your lawyer. It may take some time to find all of this evidence, depending on how keen you are on keeping things stored. Then you can do a balance sheet. Once the values of the assets and liabilities are agreed upon, you can prepare the balance sheet. And it's then easy to see the amount of the equity or the size of the pie that's to be divided between you. The second step is to look at the contributions each of you have made through the relationship and what you brought into the relationship. So it includes the income during the relationship from employment or business, any redundancy or termination payments, lump sums such as compensation payments, inheritances, windfalls, etc. As far as the lump sums are concerned, it's important as to the time when these lump sums came in and how the payments were used. If they were used to increase the assets, such as decreasing a mortgage or renovating a property, they will carry more weight than if they were used to pay joint debts or to go on a holiday. The timing of the lump sums coming in too is important, because the earlier they came in the relationship, they'll carry less weight as time elapses, particularly if it was a long relationship. And it's unlikely that a credit will be given for the whole of the lump sum contribution unless it came in at the very end of the relationship. As well as the financial contributions, we also look at the non-financial contributions, and that includes the roles of parent and homemaker and maintenance and improvement of assets such as real estate, etc. The third step is the future needs factor. Now this step considers whether one party has a greater future need than the other and whether there should be an adjustment in that person's favour. In other words, in cases where there's a long relationship, and that's 10 years or more, the starting point is often a 50-50 split of the assets, so that an adjustment may result in one partner receiving more than 50% and the other receiving less. The factors that are considered when we're looking at the future needs factors is whether they're very young children to be cared for, so the parent is unable to work on a full-time basis. If one partner has been a full-time carer of very young children and needs to retrain to return to employment. Whether one partner receives a much larger income than the other and will therefore recover more quickly from the property settlement, and whether one party may have put their career on hold so the other partner could progress in their career. Sometimes the parties relocate on a regular basis to progress the career of one of them, and the other partner was unable to be employed, and sometimes this occurs in the Defence Forces, the teaching profession, or in corporations. A judge has discretion as to whether or not an adjustment will be made for future needs, and an adjustment is not always assured. Naturally, we don't want to file an application in the court to find out what a judge has to say, but we need to take that into consideration when we're looking at the future needs. The fourth step is superannuation. In 2002, amendments to the Family Law Act enabled super funds to split entitlements to a non-member spouse. It's not unusual that one partner will have a greater amount of superannuation than the other, but it is a choice of the parties as to whether there is a split. A great deal would depend on what other assets there are and the value of those assets. A court may be reluctant to divide assets so that one partner is left with the superannuation that can't be accessed for a number of years, and the other partner receives assets that can be readily liquidated, such as real estate and shares, unless, as happens in some cases, the parties are agreeable to this arrangement. So summarising the 4 steps again: ascertain your assets and liabilities, consider the contributions of both parties financially and non-financially, whether there should be an adjustment for future needs factors, and whether the superannuation is to be split or not. Now, every property settlement is different, and the advice in this video is general advice. Don't rely on information on the internet, and don't rely on advice from well-meaning friends and relatives. This is your property settlement. You make your decisions based on legal advice, and we urge you to seek legal advice from an experienced family lawyer. So those are the basic 4 steps to follow when negotiating a property settlement. Thousands of dollars in legal fees will be saved if the parties can come to an amicable agreement. If you can agree on a property division, we can assist both parties with a negotiated fixed fee. If you just want to chat to someone who understands how overwhelming this process can be, we offer a complimentary 15-minute chat with me to give some initial advice and guidance as to what you need to do next. So whether you're thinking about separating or have already separated and are negotiating a division of your property, we're here to help you save time, stress, and legal fees. You'll find additional information and advice on our website. There are articles, blogs, motivational quotes, videos, etc., and articles by experts in areas of business, relationships, parenting, etc. You can opt in for our regular newsletters and your free copy of our ebook, Guide to Saving Money in Divorce Property Settlements. So contact Online Divorce Lawyer by phone or email and save yourself time, stress, and legal costs. Our contact details are phone 02 9016 4690, the fax is 02 4965 4569, or email is ask@onlinedivorcelawyer.com.au, and of course our website www.onlinedivorcelawyer.com.au.